Members of the jury, any action of this nature is predicated upon a claim that the defendant has been negligent because the law would not permit you to find a verdict for the plaintiff, or to award any damages unless you should recognize, first, that the accident resulted because of substantial negligence on the part of the defendant. Secondly, that there was no negligence by the minor plaintiff which contributed in any way to the accident in the city of New York. And thirdly, that the injuries and the death recalled from the accident itself. Negligence is a failure to use the care and caution which a reasonably prudent person would have exercised under the same circumstances. The reason that the plaintiff cannot receive or recover without recognizing negligence on the part of the defendant is that the law does not raise any presumption just because an accident has occurred, that the defendant has been negligent. That is a matter which you would have to find from the testimony. On the other hand, the law holds that if a claim is presented on behalf of anybody, there can be no recovery if that particular person was himself in any degree responsible for the accident. That is what is called contributory negligence. If any negligence on the part of the minor plaintiff contributed to the happening of the accident, there could be no recovery. In this case, inasmuch as the minor plaintiff died as a result of the injuries, the law requires the presumption that he was careful and that he was not contributorily negligent. It would be essential, therefore, for the defendant to prove contributory negligence on the part of the boy. That will be one of the conditions you will have to take into consideration. It is your duty to determine the facts. It is your duty to reconcile the testimony as far as you can, bearing in mind the fact that no two persons recount a thing exactly the same. Bear in mind the further fact that there is apt to be a little confusion on the part of witnesses, inexperienced in court, when they get on the witness stand, and consequently minor discrepancies may appear. You take all those factors into consideration and you bring to bear, in passing upon the facts, your judgment as to who has been telling you the truth. In other words, you pass upon the credibility of the witnesses. When you do that, you may take into consideration their interest in the outcome of the case, if any. I do not mean that just because a person may be interested in the outcome of a case that he or she is not telling the truth, because obviously in many, many instances they do speak the truth. That is merely a factor for you to consider and recognize.
What facts was that?
It was G20. 3 into 5.
31.
Back to 168.